The second essential is that when the communication was made, there should be client-advocate relationship. This means that the communication should happen when there is a relation between the client and the advocate, and when the communication happens between this relationship, then it is called privileged communication, and this cannot be taken in the court of law. This protection extends even after termination of client-lawyer relationship. Suppose you engage a lawyer and tell him all the facts regarding your case. The case is fought in the court. The case is over. Now, after the termination of the client-lawyer relationship, as the case is dismissed, as the case is over, after that, if the lawyer goes and tells to the court the facts that you have told him, then again it is a tension to the client. So the privileged communication even extends during the client-lawyer relationship and even after the client-lawyer relationship. The fourth essential is that communication is not protected if it is made after terminating relationship. This is an important point. In the third point, we are saying communication had happened during the client-lawyer relationship. That communication cannot be told by the lawyer after the termination of the relationship. So essential point is that communication should happen during the relationship. In the fourth point, we are saying communication did not happen during the relationship. Communication itself happened after the relationship of client and lawyer. Then such communication is not a privileged communication. Fifth essential, protection is available only for bona fide communications and not for furtherance of illegal purpose. The communication that the client is making should be bona fide. Suppose he has committed a murder, he can go to the lawyer and say that he has committed a murder so that the lawyer can save him. But he cannot go to a lawyer and tell the furtherance of illegal act which he is about to do. For example, what is the illegal purpose here in this example? A person prepared forged documents and told his lawyer his desire to get property by forged documents. So what is the illegal act here? The person has prepared forged documents and told the lawyer that he wants the property through this forged documents. Now what is the furtherance of illegal purpose here? Now he wants to sue the person. The first crime is that preparation of forged documents itself is a crime, is an offense. And the second offense is that with that illegal document he wants to sue the person. So for this, for furtherance of illegal purpose, protection is not available. You have committed an offense, go to your lawyer and tell all the facts, ask his help and try to get saved by the lawyer. But you cannot go to the lawyer, tell the mistake that you have, tell the offense that you have done and ask his help to commit further crime. This is not allowed in the act. Protection even extends to clerks and servants of the lawyers. So the clerks and servants, whenever they discuss anything with the lawyer or they hear the lawyer communicating with the client, these communications cannot be treated as an evidence in the court. Thus the client can be double sure that what he communicates to the lawyer, even if the servant or the clerk of the lawyer hears about it, he cannot go to the court and use that as an evidence. The second type of privileged communication is matrimonial communications. Communications between husband and wife cannot be treated as evidence. Whatever husband and wife communicate with each other cannot be taken to the court. What is the reason behind this? This simple reason: to protect the safety of the family relations. If whatever the wife and the husband talk, if anything can be taken to the court, then the relation between the husband and wife and the family will get spoiled, will be at stake. That's why the court says that, the act says that the communications between husband and wife are privileged communications. They cannot be compelled to give an evidence in the court. They are competent also, they are bound to give also, but they cannot be compelled to give evidence. If they want to give, then they can give evidence. But the main thing is that we cannot compel them to give the evidence. So long as the relationship is alive, protection is available. Simply. No protection for communication made before and after dissolution of marriage. Suppose wife, the fiancé, not the wife, suppose before engagement or before marriage, particularly before marriage, whatever the girl and the boy communicate with each other can be taken to the court. They can be even compelled to come to the court and give it as an evidence. After that marriage happens, communications during the relationship of husband and wife cannot be compelled to be taken to the court. Then what happens? Marriage is dissolved. They get divorced. After the termination of relationship, again they can be compelled to come to the court and give it as evidence. So basically, during relationship, privileged communication is there. Concept is applicable. Before and after relationship, privileged communications concept is not applicable. Protection is available even after death or divorce of the parties. If they don't want to give, then it's fine. Protection can be waived by the parties and evidence can be given. So it is optional for the parties. They are competent and they are bound to give, but we cannot compel them to give. But if they are willing to give evidence, then it's fine. When wife or husband file a case of crime against each other, protection can be waived off. Suppose a wife or husband file a case of crime against each other, then they can go to the court and say that the wife can say that the husband has said so and so thing, and that's why she is filing a case of crime against him. Or she can tell any statement, pick up any statement told by the husband during the relationship. Or husband can also do the same. Now the third category is official communications. Public interest is supreme than law. Person cannot give evidence relating to unpublished records of the state. There are some records of the state and these are not published. So a person cannot take the unpublished records and give them or produce them as an evidence. The records should be published, then only those records can be taken as a evidence. Can be given with the permission of the head of the department. General rule is that the unpublished records of the state cannot be taken as evidence, but they can be given as evidence when the permission of the head of the department is taken. It covers matters relating to friendly relations between India and other nations, matters of public interest, official documents of political and administrative nature. Communications made by an individual in official capacity are also protected. Whatever communications an individual makes on duty. So whatever communications an individual makes in his official capacity or public duty are protected. In those situations, the person cannot be compelled to act as evidence. To summarize, privileged communications generally who can be a witness, a person who is competent to give evidence, is bound to give evidence. But even then, if he is not giving evidence, we can even compel him to give evidence. But there are certain communications where, though they are competent and bound, we cannot compel them to give evidence. These communications are called privileged communications. That is, they have privileged right of not being compelled. These are of three types. Memory technique is PMO: professional, matrimonial, and official. Professional is between the client and the lawyer. Whatever the client communicates to the lawyer during their client-lawyer relationship are privileged communications. Communications made during the relationship, the protection is available even after the termination of the relationship. But the communications itself are made after the termination of relationship, then the protection is not available. Matrimonial communications, the communications made by the husband and wife are privileged communications, the reason being to protect the safety of their family relations. But the communications made before or after the divorce of the husband and wife are not privileged communications, and they can be compelled to come to the court and give evidence. But the communications made between the husband and wife during their relationship, those are privileged communications. But this is at the option of the husband and wife. They can willingly waive off this protection and go to the court and give evidence. The third one is official communications. Any communication made by the official in his official capacity, by an individual in his official capacity, are called official communications, and they are privileged communications. Any unpublished information of the court, any unpublished information of the state cannot be taken as an evidence, but it can be taken as an evidence with the permission of the head of the department. So whenever privileged communication is asked, first define who can be a witness. A person who is competent, is bound, and we can even compel him. But three cases are privileged communications: PMO, professional, matrimonial, and official. Now we will read about the rule of estoppel. What is the meaning of estoppel? Estoppel means to stop. A person is not permitted to say something one time and something thereafter. This means that a person says a statement but later makes another statement which is inconsistent or contradictory to the previous statement. When a person, by his words, written or oral, or by his conduct, creates a belief that certain facts exist, and if other person believes it, the person who created such belief will be stopped from denying the truth. This means that suppose a person A is there. He tells or writes a matter and makes the other person to believe the fact, and the other person believes it, then Mr. A cannot change the facts or deny the truth. What are the essentials? Representation by one person to another. In our example, Mr. A makes representation to Mr. B. Representation can be written or oral. The second essential is that person to whom representation is made believes and acts on it. Mr. A has given representation to Mr. B, and Mr. B has believed it to be true and even acted on it. When a person has a duty to speak but remains silent, such party will be estopped since he did not speak and induced others to believe certain facts. Example: A sold his mother's property and mother did not object. Later, mother can't say that her son had no authority to sell the property. This means that you had a duty to speak, but you remained silent. Now you cannot say, now you are stopped from saying that the person or your son had no authority to sell. When he was selling and you knew that he was selling the property, that time itself you should stop him from selling or speak up. You did not do anything. Now you cannot say that the person had no authority to do it. Any representation made must relate to facts and not law. The representation must be made, whether in writing or oral, must be related to facts, but not law. There is a difference between fact and law. Fact is what has happened in actual. That is fact. Thus, if a person gives his representation to another regarding his opinion on law, A has given representation to Mr. B on his opinion on law, the way he interprets the law, his opinion, and the other person acts on it, it doesn't amount to representation. If I tell you my advice on law, the way I interpret it, and you act on the advice, this is not representation. Because today I am interpreting the law in a different way, tomorrow I might interpret the law in a different way, depending on my experience and my law knowledge. So fact cannot be changed, but interpretation of law can be changed. Understanding can be varied, but the fact cannot be varied. There cannot be estoppel against statute or sovereign acts. For the statute and sovereign acts, we cannot stop the public servants. To summarize, rule of estoppel means to stop. That is, a person has made a statement. Later, he stopped from making a contradictory statement to the previous one. Essentials are what? A person has made a representation. Mr. A has made a representation. The second essential is that Mr. B has believed the representation to be true and even acted upon it. The third one is that representation should relate to the fact and not to law. Fourth one is that estoppel cannot be for sovereign acts or against the statute. Now we are talking about the types of estoppel, the various types of estoppel. The memory technique is R&D, NPS. Hint to remember this memory technique is R&D, research and development, we generally talk about. NPS, we talk about the NPS schemes and all. So the memory technique for the types of estoppel is R&D, NPS. R, D, N, P, S. Therefore 1, 2, 3, 4, 5 points are there. First one, R. R means record. Estoppel by record. This is also known as judgment estoppel. When a court gives judgment, the matter decided cannot be reopened by a party or his legal representative. Reason: saves a person from being vexed again and again in the same case. To give finality to litigation in public interest. So estoppel by record means once a court has given its judgment on a particular case, it cannot be again reopened by a party or his legal representative. Because once a court has given a judgment for a particular person, he cannot be punished again and again for the same cause. So once the court has punished him, then close the matter. The matter is over. You cannot punish him again. So estoppel by record. What is the record? Court has given the decision. Estoppel means what? Once the court has given a decision, the parties are stopped from reopening the case. Thus estoppel by record. Second one, estoppel by deed. In our memory technique, R and D. So R we have done, now we are doing D. Estoppel by deed. When a person is a party to a deed, later he cannot say that the facts stated in the deed are not correct. Suppose two persons create partnership deed and they write the facts in the deed and they have signed it and executed the deed. Later, either of them cannot say that the facts stated in the deed are wrong. If they were wrong, you shouldn't have signed them at all. You shouldn't have been a party to the deed at all. Once you are a party to the deed, later you cannot say that the deed itself is wrong. Thus estoppel by deed. Once the deed is made, you cannot say, you are stopped from saying that the contents of the deed are wrong. Now estoppel by negligence. In our memory technique it is N. If a person by negligence causes other person to believe in some facts, afterwards he cannot deny it. The person was not intending, or it was not intentional by the person to make the other person believe on the facts. Mr. A by mistake made Mr. B believe certain facts. Then Mr. A later cannot deny that the facts are not true or make a contradictory statement. This is estoppel by negligence. Even by negligence, if you make the other person believe, then you are estopped from denying the fact that you have told earlier. Estoppel in Pias. In our memory technique it is, in the NPS it is P. Estoppel in Pias. Also called estoppel by conduct. It arises under agreement or conduct or misrepresentation by which other person acts on it. A person, Mr. A, has done something, has done some conduct or given some misrepresentation and the other person has acted on it. Then Mr. A is compelled or estopped from denying the fact that he has given earlier. Now the fifth one is estoppel in specific cases. In our memory technique it is R and D NPS. R is record, D is for deed, N is for negligence, P is for Pias, and S is for specific cases. Estoppel in specific cases. This itself is of 4 kinds again. So what is the memory technique of specific cases? Is belt. B stands for bailee. Estoppel of bailee or licensee. Bailee cannot question bailers. Bailee cannot question bailer's right to make the bailment. A person. What is bailment? We have studied already. Bailment means Mr. A gives the goods on bail. Mr. A gives the goods to Mr. B for custody, so that when he returns from some place after some time, he takes back the goods from B. A is called the bailer, B is called the bailee, and this act of giving the goods on a temporary duration to bailee is called bailment. So bailee Mr. B cannot question bailer's right to make bailment. When Mr. A goes and gives goods to B for keeping in safe custody for some temporary period, B cannot ask A whether you have the right to make the bailment. Similarly, licensee cannot question licensor's authority to grant license. The licensor will grant license to the licensee if he applies. While taking the licensee cannot question his authority. So estoppel by bailee or licensee means bailee cannot question bailor's right, licensee cannot question licensor's authority. Estoppel by acceptor, estoppel of acceptor of bill of exchange. In our memory technique, belt, B is over bailee, E stands for exchange, bill of exchange, BOE. A person after accepting bill of exchange cannot say that the drawer had no authority, but he can show that the signature of the drawee was forged. Bill of exchange we know what it is already. It is an undertaking that the person who is signing will pay the required amount to the holder, and bill of exchange can even be taken to the bank, and the bank will take the bill and give the money to the holder of the bill of exchange after cutting their commission. So bill of exchange means that it acts like we cannot say exactly like money, but it acts like a promissory note, an undertaking that the money will be given, a credit note, or not a credit note, an undertaking that the money will be given in future time. So a person after accepting the bill of exchange, suppose the banker accepts the bill of exchange, later on he cannot say that the drawer had no authority to give the bill of exchange. Estoppel of licensee of person in possession. A person to whom license is granted by a person in possession of property cannot say that he had no right to possession of the property. Suppose a person has a possession of property, fine. Then the person who has the possession of the property gives the person who has the possession of the property gives license to the other person. The other person cannot say that the person in possession of the property has no authority to give such license. L is over BEL, B for bailee, E for exchange, bill of exchange, L for licensee, T for tenants. Estoppel of tenants. When a person becomes a lessee of immovable property, later he cannot say that his landlord had no title to the property at the time of commencement of lease. What is this lease? It is a form of rent. I am the owner of the property. I give you the property on rent for a very long period of time. It is similar to rent. It is not exactly like rent. And I am the owner of the property. I give you the property on lease for a very, very long period of time, almost through the life of the asset. Then it is called as lease. And if it is not equal to the life of the asset, then it is called as rent. Suppose 5 years, 2 years, 3 years, like that. Leases are for about 20 years, 30 years, 50 years, like that. So I am the landlord. I am called the lessor, and I am giving you the property on rent, that is lease, and you are called the lessee. So Mr. A gives his property on rent or lease to Mr. B. When a person becomes a lessee, Mr. B, of immovable property, later Mr. B cannot say that his landlord, Mr. A, had no title to the property at the time of commencement of lease. Mr. A has given the property on lease to Mr. B. Mr. B has accepted the property and the lease has commenced. Later, B cannot say that Mr. A did not have the authority to give the property on lease at all. When landlord files a suit for eviction of tenant, Mr. A goes to the court and files a suit that he wants the tenant to, Mr. B, to leave the property, vacate the property. Then the tenant, Mr. B, can question about his title. Because when the landlord is complaining about the lessee gets the right to tell that you're trying to remove me from the property. What right do you have on the property itself? So what is the crux of this? Does the landlord file suit of eviction of tenant? Eviction means removal, vacate the property. Does the landlord file suit of eviction of tenant? Is Mr. A filing a suit to remove Mr. B? If he is not filing, then the tenant Mr. B cannot question his right on the property. If Mr. A is filing a suit to remove Mr. B, then Mr. B can question Mr. A his right on the property. To summarize, types of estoppel. Estoppel means to stop. Memory technique is R&D NPS. R stands for estoppel by record. It means that once a judgment is given by a court, the party or his legal representative is estopped or stopped from reopening the case. The second memory technique is deed. Once you are a party to the deed, you cannot say it later that the contents of the deed were wrong. N stands for negligence. Even if by negligence you make other person believe that the facts are true and the other person believes it to be true and acts on it, then you cannot deny it later, the facts that you have told already. P for Pias, estoppel by conduct. Once you have made the other person believe that the facts are true, then later you cannot deny it. Estoppel in specific cases, NPS S. Then again in specific cases we have another memory technique of belt. B stands for bailee. Bailee cannot question bailor's right to bail. Lessee cannot question the lessor's right to grant the license. E stands for exchange, bill of exchange. After accepting, before accepting you can deny or you can say what's your right, but after accepting the bill of exchange, a person cannot say that the drawer had no right. Estoppel of licensee, of person in possession. A person is in possession of the property. He grants license of the property to other person. He accepts it. Later he cannot question the person who is in property what right he had on the property. So B is bailee, E for exchange, bill of exchange, L is for licensee, T is for tenants, estoppel of tenants. Once the tenant accepts the property on lease, he cannot question the landlord about his right on the property. But if the landlord files a suit against the tenant for eviction of the tenant, for the removal of the tenant, then the tenant can question his landlord's authority on the property. So crux is what? If landlord files a suit, yes, he files a suit, then tenant can question. If he does not file the suit, no, the tenant cannot question. Fourth question, what is patent and latent ambiguity or ambiguous document? There are two types of ambiguities, patent and latent. Patent ambiguity, it is a defect. Ambiguity means defect. It is a defect in the document on the face of it. By looking at the document itself, you can say that there is a mistake in the document. It's a prima facie defect. Defect which could be noticed easily by a simple reading of the contents of the document is a patent ambiguity. Patent means visible, clear, prima facie. Patent means prima facie. If the language used in the document is defective, oral evidence cannot be given for it. If the language is defective, oral evidence cannot be given. Example, A offers to sell his house for rupees 1 or 2 crore. Rupees 1 or 2 crore. This clearly looks that on reading of the sentence itself, we can understand that there is some ambiguity, there is some defect. Thus, there is a defective language, and this is the patent ambiguity, very evident. Oral evidence cannot be given for it. When content of the document is clear, oral evidence cannot be given. Whether the content is clear or unclear, oral evidence cannot be given for patent ambiguity. Example, A offers to sell his house at Chadarghat. Content is clear, and in fact A has a house there. Crux, oral evidence cannot be given both when the content is clear or unclear. Clear is in our example it is Chadarghat, unclear in our example it is 1 or 2 crores. What is latent ambiguity? Latent means not apparent. Although the language used is clear, but it is inconsistent with the facts. By reading the document itself, we cannot identify that there is a defect in the document. If it is identified like that by reading itself, then it is a patent ambiguity. If you cannot identify just by reading the document that there is a defect in the document, then it is a latent ambiguity. The language is clear, the language is correct, but it is not consistent with the fact. For latent ambiguity, oral evidence is allowed. We'll take an example for it. Suppose A offers to sell his house at Bashir Bagh, but in fact he has a house at Chadarghat. What it means? Suppose you read the sentence, A offers to sell his house at Bashir Bagh. By reading the sentence, it looks that it is correct, but it is not matching with the fact. What is the fact? A is not having a house at Bashir Bagh. A is having a house at Chadarghat. So both the conditions are being satisfied here. First condition is that it is not looking as a mistake just by reading the line, and the second is that it is not matching with the fact, it is inconsistent with the fact. Thus it is a latent ambiguity. For this latent ambiguity, oral evidence can be given to show that the document in fact referred to the house at Chadarghat and not at Bashir Bagh. Oral evidence can also be given when can we give oral evidence? Language is clear and it is consistent with the fact also, but it is difficult to decide to which it applies. First one, what was the case? Language was clear. Here also language was clear. Second was that in the first situation, first point, language is clear. Second point is that it is inconsistent with the fact. But in the second situation, what is it? The language is clear, it is consistent with the fact, but it is difficult to decide to which it applies. So example, A offers to sell his house at Chadarghat. First, language is clear. There is no apparent mistake, so this is not a patent ambiguity, it is a latent ambiguity. Second, it is consistent with the fact how the Mr. A actually has a house at Chadarghat. Third, it is difficult to decide to which it applies. Why? Because A has not only one house at Chadarghat, he has two houses. So the ambiguity is what? Language is correct, fact is also consistent, but ambiguity is what? A intends to sell which house at Chadarghat? Which of the two houses at Chadarghat? So for this, oral evidences can be accepted to clear the doubt, to clear the ambiguity. Let us read. Language is clear, yes, it is clear. A in fact has a house at Chadarghat, so this is consistent with the fact, but A has two houses at Chadarghat. So it is difficult to decide A wants to sell which of the two houses. For this, oral evidence can be taken to clarify. Oral evidence can be given when language used in the document partly applies to one set of facts and partly to another. Example, A wants to sell his house at Chadarghat, which is in possession of B. So there are two facts here. First one, he wants to sell his house at Chadarghat. Second fact is what? It is in possession of Mr. B. But the fact is what? He has house at Chadarghat. Fine. This is partly related to one fact. But house is in possession of B. But house in possession of B is at Charminar. So this is partly related to another fact. To clarify this, oral evidence can be given. First fact is what? House, he wants to sell house at Chadarghat. This is one fact. And he says that this is in possession of B. But in fact, it is not in possession of B. The house which is in possession of B is at Charminar and not Chadarghat. So there are two facts which are partly true. For this, oral evidence can be given. Next, Oral evidence can also be given to explain the meaning of foreign words, phrases, etc., which are commonly understood, which are not commonly understood. Suppose you use some words, foreign words or phrases which are not commonly used by any layman. So to explain them, you can use oral evidence. To summarize, what is an ambiguous document and what are the types, what is the meaning of patent ambiguity and latent ambiguity? Patent, as I said, to remember patent prima facie, that is apparent from the record. Just by reading the document itself, you can say that, oh, there is a mistake in the document. For this, oral evidence cannot be given. Latent ambiguity is what? By reading the document, you cannot say that there is a mistake. If you go read the language will be correct, but fact will be inconsistent. Then oral evidence can be allowed. Language is clear, fact is also consistent, but it is difficult to decide to which it applies. Then oral evidence can be given. The third situation is what? Language and all, forget it now. The fact, there are two facts in the question, and one fact is partly true and then another fact is also partly true. For this also, oral evidence can be given. Then, if you are using some foreign words or phrases which are not commonly used by layman, then you can give oral evidence to clarify to those words and phrases used. That's it. Questions from question 5 to question 22 will be covered in the next video. Hope you like it. Thank you.